said, what I want to do is turn to witness orders now under Rules 32 and 33. The Tribunal's got a power to order any person in Great Britain to attend a hearing, to give evidence, or to produce documents, or to produce information. So it's a very extensive power, and it's not simply a question of evidence giving. It could be to produce documents, or it could be to produce information. There's a separate procedure for taking evidence in other EU member states. It doesn't apply in Denmark. If the court of a state, in accordance with the provisions of the law of that state, requests, then the competent court of another member state can take evidence, or it can make the request to take the evidence directly itself in the other member state. Now, if you have a situation in which this may crop up, there's an EC regulation 1026/2001, and that sets out in detail the procedure that's to be followed. So you can take the tribunal to that and invite them to apply that procedure. Next, I want to talk about parties and substituting parties and also interested parties. The materials on this you can find at Rule 34 and 35. The general rule is that the Employment Tribunal can, on its own initiative or on application of a party or any other person who wants to become a party, add a person as a party by way of substitution or otherwise. However, it's got to appear that there are issues between that person and any of the existing parties falling within the jurisdiction of the tribunal, and the tribunal has to conclude that it's in the interests of justice to have those issues determined in the proceedings. The tribunal can also remove any party that apparently has wrongly been included. One other interesting power that the tribunal has is that it can allow any person to participate in proceedings on terms that may be specified in respect of any matter in which that person has a legitimate interest. One of the things that will need to be worked out is what a legitimate interest means in this situation. But it could mean, for example, that a trade organisation would want to make representations if the tribunal was going to be interpreting a contract which is common to all employment within that trade. And equally, a union might want to make representations in a case where collective bargaining issues are at stake.